Welcome to our video on the offer to purchase for homes in Haasendal Estate. Whether you're a first-time home buyer or a seasoned pro, understanding the legal terms in your purchase agreement is crucial. So grab a cup of coffee and let's dive in. This video is for informational purposes only and not legal advice. The developer, House of Realtors, and any of its affiliates cannot be held responsible for inaccuracies and should not be relied upon as a substitute for professional legal advice. Clause 6. Purchase price and payment. This clause outlines the payment terms of the agreement. The purchase price will be paid in two parts: a deposit to be paid to the attorneys and the balance in cash upon registration of transfer. Within 21 days of signing the agreement, the purchaser must provide a bank guarantee acceptable to the seller. All payments must be made to the attorneys and must include a specific reference number to avoid potential loss. The seller and attorneys are indemnified in case of non-compliance. Clause 7, this is construction, occupation, risk and occupational rental. This clause outlines the construction, occupation and risk related terms for the offer to purchase. The seller will commence construction of the improvements and complete them within a reasonable period of time. The purchaser will take possession on the practical completion date, and any defects or incomplete works will be documented and remedied within 3 months. The purchaser will pay occupational rent until the transfer date, which will be calculated as per the schedule. The purchaser can claim compensation only if the improvements are more than 5% smaller than agreed upon. The seller has restricted the purchaser's choice of improvements to a fixed number of plans. The purchaser can request variations or extra work, which will be quoted and paid for accordingly. The right to change the plans will terminate after a specified time, after which the right to do so will lapse. Clause 9. Transfer and cooperation. In this clause, it is stated that the registration of transfer will be done by the attorneys as soon as possible after the practical completion date, provided that the purchaser has fulfilled all of their obligations. If there is a dispute over the practical completion date, then the decision of the seller's architect will be final. The purchaser is required to cooperate with the seller and attorneys, provide necessary documentation and information, attend appointments, and sign all required documents within a specified time frame. Failure to comply with these obligations is considered a material breach of the agreement. Finally, the seller is not liable for any loss or damage resulting from transfer of registration delays, and the purchaser is still liable for any applicable interest payments. Clause 10. Costs. In simple terms, the seller will pay for the transfer costs of the property, but the purchaser will be responsible for paying any bond registration fees, financial institution fees, interim interest, and attorney fees. If the purchaser fails to pay these costs, the seller has the right to make payment on behalf of the purchaser and be reimbursed with interest. Clause 11. Loan finance. This section outlines the terms regarding mortgage financing for the purchase of the property. If the purchaser requires a mortgage loan, it must be approved within 21 days of the signature date, and the seller is authorized to assist with the application. If the loan is not approved, the agreement will lapse and the seller will refund the deposit and any payments made towards the purchase price. The purchaser must apply for mortgage financing through the mortgage originator appointed by the seller or else pay a penalty. The purchaser is responsible for ensuring that the financial institution instructs the attorneys to register the mortgage, and all associated costs are to be borne by the purchaser. Clause 12. Warranties. This section outlines the warranties provided by the seller for the property being sold. The seller provides a warranty of quality for 6 months after the transfer date, as well as the standard home builders warranty prescribed by the National Home Builders Registration Council. The seller is only responsible for defects arising from faulty workmanship and materials, and not for any wear and tear, misuse, neglect, or other damage caused by the buyer. Any defects must be reported to the seller within the warranty period. The buyer cannot make any claims against the seller for any loss or injury resulting from defects in the property beyond the seller's control, or any acts of omissions by other buyers in the development. The buyer can only use the property for residential accommodation purposes. Clause 13, Property Owners Association. The purchaser acknowledges that they will be part of a property homeowners association, responsible for maintenance, control of the road and parking areas, and regulation of property construction or improvements. The purchaser will also be liable for payment of levies raised by the association from the transfer or practical completion date, whichever comes first. Clause 14, Restriction on Alienation. The purchaser acknowledges that title conditions will be imposed on the property, which state that the property cannot be sold or transferred without the written consent of the trustees of the Property Owners Association, and that the purchaser and their successors will be members of the Property Owners Association. The purchaser must disclose these clauses to any prospective buyer and obtain their written acknowledgement and consent before transferring the property. The purchaser remains obligated to the Property Owners Association even after the property is transferred with consent. Clause 15, Direct Marketing and Cooling Off. This agreement states that if the transaction has resulted from direct marketing, the purchaser has the right to cancel the agreement within 5 business days of delivery, but the seller cannot accept this risk as they will have already incurred costs. Therefore, the seller is not willing to enter into this agreement if the transaction resulted from direct marketing. The purchaser warrants that this transaction did not result from direct marketing, and if they successfully cancel the agreement after delivery, they will be liable for damages suffered by the seller due to the breach of warranty. Clause 16, General. In this clause, it is stated that all terms of the agreement are recorded in writing and no variation or cancellation is binding unless written and signed by the parties. The purchaser is liable for all obligations and the liability cannot be divided among multiple purchasers. The purchaser must be up to date with South African Revenue Services obligations. Any promises made by the seller must be recorded in Schedule A, and the purchaser must confirm that no other promises were made. If a matter is disputed, either party can have it considered by an independent architect. The layout of the development may still change, and the purchaser cannot cancel the agreement unless the change significantly affects the property's position and extent. Clause 18, Chosen addresses for service of notices. This clause determines the addresses at which the parties will accept all notices, including legal notices and summonses. The seller will receive notices at the address recorded in the definitions, and the purchaser will receive notices at the address recorded in Schedule A until the transfer date and thereafter at the address of the property sold. Notices can be sent by post, hand delivery, fax, or email. If sent by post, it will be deemed received on the 4th business day after posting. Any notice received by a party shall be adequate written notice, even if not sent to the designated address. The seller has the right to appoint attorneys as an agent to give effect to the terms and conditions of this agreement, and any notice issued by the attorneys will be deemed sufficient notice from the seller. Clause 19, jurisdiction and legal costs. This clause states that the agreement is considered concluded when the seller accepts the offer, even if they are only told of the acceptance afterwards. The parties agree to the jurisdiction of the magistrate's court for any disputes arising from the agreement, but either party can still choose to take legal action in any other court. The successful party in any legal proceedings will be entitled to recover their legal costs from the other party. Clause 20, default. If either party breaches this agreement and does not fix it within 7 days of being notified, the other party has the right to cancel the agreement or claim immediate performance or payment. If the purchaser breaches and the agreement is cancelled, the seller can keep the deposit as agreed damages. If the seller breaches and the agreement is cancelled, they must refund the deposit and pay the purchaser the same amount as agreed damages. The innocent party may cancel the agreement later if the breach is not fixed. And if the breach cannot be fixed within 7 days, the notice to fix it will only allow cancellation if a reasonable period is given. If the purchaser fails to pay on time, interest will be charged. Clause 22, suretyship. Suretyship means that if the purchaser is a company, closed corporation or trust, the person who signs the purchase agreement is responsible for all the obligations of the purchaser under the agreement. The person is called the surety, and they waive the right to ask the seller to first try to collect payment from the purchaser before going after them. If the purchaser fails to fulfill its obligations, the seller can hold the surety fully liable for damages. Clause 23, company or closed corporation to be formed. If the purchaser is in the process of forming a company or closed corporation, the signatory of the purchase agreement will be personally liable for all the obligations of the purchaser if the company is not incorporated within 45 days of the signature date, or if it fails to ratify the transaction within 7 days of incorporation. If the company is incorporated in time and ratifies the transaction, the signatory will be bound as a surety for the purchaser's obligations, and the seller can hold the signatory fully liable for damages without first proceeding against the company or closed corporation. The signatory waives the benefit of excusation, meaning that the seller can go directly to the signatory for payment without first exhausting other remedies. Thank you for watching this video on the offer to purchase agreement for turnkey homes in Haasendal Estate. We hope that it's provided you with helpful insights and information. If you have any further questions, kindly reach out to the agent who can put you in contact with the attorneys and provide you with the relevant responses. Thank you very much. Have a good day.